Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I would like to pose a rhetorical question, calling upon all of us to render our opinions under the First Amendment as to whether the stipulation for a non-dissemination order that led to the very first non-dissemination order has created more harm than good. Let's take a look at what the original stipulation between these parties that have been at odds over so many things agreed to back on January 3rd, 2023. It says here, comes now Brian C. Kohberger by and through his undersigned attorneys, Ann C. Taylor, Public Defender, and J. Weston Logston, Chief Deputy Litigation, and Latah County Prosecutor William W. Thompson, Jr., hereby stipulate, and that means agree to the issuance of a non-dissemination order prohibiting attorneys, investigators, and law enforcement personnel from making any extrajudicial statement, written or oral, concerning this case, other than a quotation from or a reference to, without comment, the public records of the court in this case. Now, a couple of comments regarding this first paragraph. At this time, 2+ years ago, Ms. Taylor was a public defender. She has since moved on and opened up her own law firm. And there was a third attorney added to the defense team, Alyssa Massoth, who was not around at the very beginning of the case. And Mr. Thompson, he primarily worked on the case, and then he brought in Ashley Jennings to assist him. And then there were the attorney generals of the state of Idaho that also made appearances in this case. But this is who the original attorneys were: Mr. Logston, Ms. Taylor, and Mr. Thompson. The stipulation, it goes on, is based on the Sixth Amendment and the defendant's and state's interest under both the Idaho and U.S. Constitution. This order has both a constitutional duty and we have to go on to page 2 to continue, and the inherent authority to minimize the effects of prejudicial pretrial publicity, and to ensure the efficient administration of justice. And then the parties cite to both U.S. Supreme Court law and Idaho Supreme Court law here. The next paragraph states, as this court is aware, this case involves matters that have reached a great deal of publicity, or received a great deal of publicity. The United States Supreme Court has identified non-dissemination orders as being properly, narrowly tailored, as well as the least restrictive means to ensure a fair trial in the view of First Amendment protections. And this cites to 2 U.S. Supreme Court cases. Therefore, the parties stipulate, that means they agree, that a non-dissemination order be issued to protect against adversely affecting the integrity of the case to be presented at trial. Now that sounds very important, unquestionable. Unquestionably, should both sides be entitled and able to present their case without prejudice. But the question here is, by having such an airtight non-dissemination order from the early days of the case, and we know that this order was rendered on the same day as this stipulation was filed. If you go to January 3rd, 2023, you will see the order signed by the first judicial officer who ever presided over this case in Idaho. That is Magistrate Judge Marshall, Megan E. Marshall. And what it does, is the stipulation says, is it prevents all of the parties involved that would have access to this large amount of information that is under seal, and it continues to be under seal. And it is not until you look at the case summary page maintained by the clerk of court that you realize how many things have been under seal since the beginning of the case and continue to be. So the question is, might there have been less of these wild conspiracy theories on both sides of the fence? Those in favor of the state's case, those in favor of the defense's case, if once in a while there could have been a permissible interview or press conference given, as we see in other cases, by Mr. Thompson or, respectively, by Ms. Taylor. We've seen none of that because of this non-dissemination order. What's your opinion on this? Do you feel that it has unintentionally done more harm than good? Do you think that things should be loosened a little bit regarding the evidence that remains under seal? Do you think that the attorney should be able to give a press conference or give an interview to the press once in a while? Or do you think things should remain exactly as they are until trial this summer? Please leave your thoughts, your comments, your opinions. They're all appreciated. And if you do like our content, please subscribe to the channel. It helps us out so much. This is Kathy. Thank you as always for joining us here today.